responsible beyond a certain point for what is happening in the public authority, etc., etc. But I think broadly speaking, it was a very positive sort of thing, and I would, taking up the point that the Information Commissioner from Arunachal made, I would strongly recommend that, Colin, if you could send out detailed minutes of the meeting, it might be very useful to even those commissioners who did not come for this meeting. Then the other thing was that we also discussed the other forms of denial apart from Section 8. And unfortunately, we did not get yesterday that table which would show us how many of these were, which didn't come. But I'm hoping that you could then circulate it later on to all the participants so that people get some statistics about how often provisions which are not strictly within the law are being used by commissions across the country to reject applications or deny. I think it's very important because that then sets up the flag in the mind of Information Commissioner that I must be careful. I remember, I won't mention names, my informally talking to one Information Commissioner and saying to him, a Chief Information Commissioner, that look, we've been looking at your orders and you seem to be using this particular section in a way in which I'm not sure if it is appropriate. And a 5-minute discussion made him think, and he said, okay, I think I understand now. And then later on we checked and he had actually changed the way in which he was using that. So what I'm saying is that there is a fair amount of open-mindedness among commissioners who, if they are rationally and reasonably pointed out some of these things, and so I think we need to circulate these things to them. Then of course there was the whole order about the continuing mandamus and the arrest warrants, where we particularly missed you, Arvind, because this is your favorite thing. And I think the points that came across very strongly, one was the plea, and I think Shailesh made this very strongly, that continuing mandamus is alright for those commissions where you're dealing with 10 or 15 or 20 cases. But he made out a balance between how quickly you dispose of cases and whether you can continue to have continuing mandamus. Now, to this point, let me also mention, link back to something that Justice Shah had said in the morning. Because he had given a view that once you've given a final order, legally you cannot reopen that case. So he had also said that, look, if you want to take any further action, you've got to adopt some sort of a continuing mandamus system. Mr. K.K. Mishra today pointed out that at least the Karnataka High Court has come up with some very progressive orders which could then be used for this. So I think we need to gather this together and build up a sort of an approach, because he might be right that maybe in 4 or 5 information commissions in the country, or 8 or 9, where there's a huge pressure, we might have to have a modified system. But at least in the remaining ones, we could try and adopt this and maybe have an amended or modified system for these. So I think some more thinking needs to be done. Yeah, many of them said they were doing continuing mandamus, but there are many issues. In fact, again, this study shows that the data doesn't tell you very clearly that if this was effective or not every case. There was also a further important issues about these arrest warrants, and I think a distinction was made that why are we talking about arrest warrants? It was felt that as far as making sure that PIOs attend the hearings for appeals and complaints, there was a suggestion which I think was not significantly opposed, that why should one bother? If they don't come, they don't come. Just issue the order and finish with it. Why unnecessarily get into this? The second part was that where you needed oral evidence or you needed records which were not forthcoming, that could be an appropriate place to issue arrest warrants, but it would have to be done judiciously, because otherwise, like many other things, it might lose its effectivity if everybody is making an arrest warrant. Third was that you might use it to sort of force public authorities or PIOs to do things. Meaning it could be a threat over their head saying that if you are not giving information or not doing what the commission wants, we will harass you and call you and summon you and you can sit here. And there was a general feeling that this is the sort of thing we should be very careful about, because this sort of thing can also then have repercussions. So there was a large discussion on this, but partly perhaps because you were not there was no final conclusion on this particular point. I wasn't here, unfortunately, this morning, so I can't summarize that for you if somebody else wants to do it.
The delays, backlogs and role of penalties, which took about 1.5 sessions, was an extremely useful, extremely participative discussion. Nearly everyone in this, in this hall participated in that. I think some of the friends from Maharashtra and Uttar Pradesh, they contributed significantly to that session, and it was two things were agreed upon. One is that the information commissioners, in particular, should be urged. This committee and in this seminar, everybody present urged the information commissioners that they should use the penalty provisions more frequently and rigorously as and when necessary, because that would then create an atmosphere of urgency about this. But it was also agreed that, having said that, it should be left to the commissioners to use it the way they think appropriate within the frontiers of the law. On one point which was made and which was made and to which there can be an exception is that when you do not wish to use a penalty provision when there is a need to use it, then shouldn't be saying why you are not using it. However briefly you might say. That was one of the points which was made, and I think that it's an unexceptional point. So hopefully people around the table would take it back and appropriately act on. So about the remanding back and difference between complaints and appeals, also a very extremely useful discussion took place. It was generally agreed that as far as this law is concerned, there is very little difference between a complaint and an appeal. So therefore the way the commissions are treating with complaints and appeals also sometimes overlap, and so the line is very blurred. So sometimes even complaints are treated like appeals, sometimes appeals are treated like complaints. So therefore on that also I think there was generally a sense of some consensus. If you would like to add something.
Then the last two sessions, when I walked in, of course, the session on the appointment of information commissioners was going on, and I'm not sure whether it went the way we were hoping it would go, because I think there was a feeling that if we can get some sort of a consensus and signatures, and I think I was the spoiler out there, because you'd almost reached a point where people were perhaps willing to say they'll sign, and then I sort of put my foot into it. But I honestly think that it is an issue which requires a little, I think we need to sit and discuss it more with the other side also. I mean, I think we need to discuss it with governments and information commissioners also a little more, so that a method which gets evolved is a method which is a workable method. But that's what seemed to emerge. Finally, the section 4. Now, I'm one of those who believes that Section 4 is the future of the RTI. I mean, I feel that the Act should wither away. If it was successful in 4 or 5 years, most of the information commissioners should be free to play golf at least 4 days out of 5 in a week and have a few appeals and complaints that come up. Because if Section 4 is adequately implemented, I think 99% or 95% of this information should become so more available, and people should not have to come into this whole process. I think the discussion seemed to suggest ways in which we could implement Section 4 more effectively, some of which needs to be developed further. In fact, I would strongly suggest to Colin that if you could provide a legal opinion, which is well thought out, about what in your view are the remedies available in the Act if there is a non-compliance with Section 4, both from the penalty side, or all three, the penalty side, the disciplinary action side, and the compensation side.
It might just one second. I think that it's not purely a legal problem. There is a logistical problem also. I mean, we have to, in some key actors, namely representing major ministries and departments and undertakings like railways or the home ministry, one should sit across with them and find out what is the status of their record, and if they are asked to put it the way in which the law expects them to, can they do it? Are they in a position to do it?
No,
because otherwise you will be passing an order which will never be, I mean, whatever be the penalty, is not going to be implemented the way it is expected. So I think that it would be good to help the government departments after understanding what is the, how easy or difficult it is to put up whatever you want under the 411B to put up.
I totally agree with you, Mishra Sahab. The only question I have in my mind, and here Shailesh and I have also often disagreed, it's the chicken and egg question. See, when you are in the government, you sometimes feel, look, unnecessarily you're doing this, we have to sort out our problems. But people like us outside the government feel that the motivation to sort this problem out will not come till there's pressure from outside. So suppose, for example, people start getting penalized.